Hey, good morning, everybody, and I guess early afternoon to the folks here on the East Coast. We want to welcome everybody. My name is Shannon Kasley. I am a litigation partner in the environmental mass tort here at McGuireWoods team here in DC. And I'm also the co-lead of our PFAS and emerging contaminants practice area. I just want to say a quick word of thanks to our clients and firm friends who are attending today. I think this is our fourth installment of our Contaminants Compass CLE series. And I think we have a number of signups for today. So hopefully folks were able to join us. This is the fourth in the series that I mentioned. This is a litigation update. Our first was with Adam Sawatzka and Congresswoman Madeline Dean back in January, sort of a look forward in terms of legislative initiatives with respect to PFAS. Our second session was with Joe Eisert and our insurance folks. Our most recent update was with Dave Franchina and our transactional folks. And then today, I'm really excited for Michael and Ryan to participate in a bit of an update and then a roundtable. We're hopeful that folks find it interesting. Please don't hesitate to ask questions. We may save them till the end, depending on the number of questions, but please don't hesitate to use the Q&A function. And Beth, if you go ahead and advance to the next slide, I'll go ahead and let Michael and Ryan introduce themselves and we'll get started.
You bet. Thanks so much, Shannon. I'm Michael Easley. I am a McGuireWoods partner, and until recently, I was the United States Attorney here in the Research Triangle in Raleigh, North Carolina. Prior to that, I was a partner at McGuireWoods, focusing on environmental enforcement matters, and particularly when they tie in to big government investigations that have criminal exposure. I have thousands of hours working on PFAS-related matters and handled one of the earliest and most significant criminal investigations related to PFAS. Have a lot of experience with the Clean Water Act and how the permit shield can apply around issues related to PFAS in processed water. My work as U.S. Attorney placed me as the top federal law enforcement official in my region and served on the Attorney General's Advisory Committee for white collar and corporate fraud investigations and handled the government's relatively new voluntary self-disclosure program, which provides an avenue to self-disclose violations of law and avoid potential criminal liability. I brought to my role at the Justice Department many years of experience representing institutions that were facing really challenging environmental issues. And now I'm able to bring both of those experiences back, both as a regulator and a defense counsel, to help manage crisis when it emerges. So really proud of the PFAS team we have here. We've been involved in this for so many years, and the wealth of insight that Shannon brings is really unmatched. So grateful to be among you.
Thanks. Yeah, and I'm Ryan Park. I am also a partner here in our firm's Raleigh office. Up until recently, I was the state of North Carolina's top appellate lawyer. I was Solicitor General of the state for 5 years. And in that capacity, I managed the state's complex litigation and constitutional litigation, including some of the litigation involving PFAS. And I was involved in the state's lawsuit against manufacturers of PFAS products. And prior to my time in government, I was at another national law firm and was involved in defending companies against some of the claims that I'll discuss here in terms of labeling claims that we're now seeing popping up in the PFAS context. So excited to be here and happy to meet with you all.
Great, thanks, Michael and Ryan. If Beth, if you go ahead and advance to the next slide, just so folks sort of know where we're going. Here's an agenda. I will provide hopefully a brief overview of sort of the PFAS litigation history, and any discussion of that will, of course, involve a discussion of, I think, really what most people are aware of in terms of the ongoing PFAS litigation, which is the firefighting foam, which is called the AFFF, the MDL in South Carolina Federal Court. We'll touch on that. And then Michael will talk about some of the expanding litigation that we're seeing, and sort of where it's, we think it's headed, and ongoing matters. And then Ryan and Michael and I will sort of identify as best we can some evolving trends that we've identified, and then also, I think, really uniquely, some federal and state perspectives based upon Michael and Ryan's background and careers in government. And then hopefully we'll have time for the Q&A at the end. But that's sort of the overview. And Beth, if you go ahead and advance to the next slide after that. Thank you. So, an overview of PFAS litigation history. It is still relatively recent litigation in terms of, some of the bigger dockets in terms of products liability. It started in the late 1990s. Most scholars identify a single case in West Virginia by a farmer having to do with, I think it was in 1999, having to do with harm to his livestock. A single plaintiff lawsuit against a manufacturer, PFAS manufacturer with facilities in West Virginia. Sort of a relatively narrow start in terms of scope. Very quickly after that, in the early 2000s, were the first state AG actions. And they were, again, somewhat narrow in scope. You see there were really 4 states that were involved, almost exclusively in connection with manufacturing facilities. And they were all focused on natural resource damages. And all of those lawsuits resulted in significant, at the time and even today, settlements in the hundreds of millions of dollars. But for a number of years, those settlements were sort of tightly controlled by the states in restricted grant programs. And so kind of a sort of a narrow beginning and a focused beginning, really. And it really has, I think folks are aware, exploded in the last 25 years or so, 13,000 lawsuits by most counts. And you can imagine every kind of claim sort of from these, early beginnings and sort of evolving. And we'll talk more today, certainly in more focused detail, on some of those evolving lawsuits and claims and parties. Certainly there has been a movement pretty significantly away from the manufacturers. The manufacturers are still named quite frequently, but much further down the supply chain in terms of defendants, and even defendants who don't know that PFAS is either in their processes or in their products. And so it's really sort of an evolving, even after 25 years, there are still sort of new theories coming out, and certainly new claims and new defendants. Beth, you can go ahead and advance. So that was a little bit of a lead in terms of the liability types and the common alleged exposures. Certainly the litigation from the very beginning focused on the manufacturers, 3M and DuPont. That really continues to today in a number of different sort of avenues and claims, whether it be personal injury, whether it be environmental, whether it be even now under CERCLA in cleanup efforts. As you start to move down the chain, I believe in one of our sessions, and I think I misspoke earlier, it was Joe Englert who did our insurance discussion back in March, I believe, and Marsh was involved and kind of identified this flow chart of liability. I think they called it the taxonomy of liability, and they kind of tracked the various steps in the lawsuit. So you see that here. Companies that I think they know they're using PFAS in their manufacturing. One of the well-known cases is the Wolverine footwear brand in Michigan, where they knew they were treating the footwear, boots and things like that with PFAS. And so the Michigan AG, that was a separate lawsuit involving 3M and Wolverine. As you kind of continue down the chain, certainly chemicals or companies that owned or continue to own properties where PFAS chemicals were used. One of the really more recent well-known ones is the Solvay settlement with the New Jersey AG in the last couple of years, where they had facilities in New Jersey where they were using PFAS chemicals in their processes. Again, the New Jersey AG, we'll talk about a little bit, has been very involved throughout sort of the history of this PFAS litigation with manufacturers and then also with folks using it in their processes. Firefighting foam, that is sort of its own animal. We'll talk about that as well. And then as we start to move down the supply chain, there are companies using PFAS-treated components and equipment. PFAS is used as a surfactant. It is used in lubricants. It is used in gaskets, hosing, piping. And so we have started to see litigation where the PFAS is either leaching or somehow getting into products or somehow into the environment through the use of these components and equipment. And then we'll also talk later, Michael and I will talk sort of at the very end, if you think about it in terms of supply chain, waste disposal and beneficial uses. There we're talking about things like biosolids, sludge, that have all sorts of uses, treated wastewater or processed water that also has a number of uses, including in agriculture. And so we'll talk about that as well. Beth, go ahead and advance. We can do one more. So, an overview of the firefighting foam, the AFFF multi-district litigation in South Carolina. This really is important, I think, in a lot of ways in terms of litigation updates, even if you're not involved in firefighting foam, because a lot of law is coming out of this MDL. You can see it started back in 2018 with 75 cases, and now the number has jumped to nearly 13,000 cases, over 30,000 plaintiffs, and nearly 150 defendants. To say that it's a sprawling MDL is probably an understatement. It has actually been criticized by a number of folks who study class actions, who study the MDL process, just about how big it is, how many claims are involved, and this just gives you a sense of it. I don't even know that this is a complete list of the claims that are at issue, all having to do with firefighting foam, but they involve water districts. Those were the first cases filed. We have state AG claims for all sorts of environmental and other harm. We have a docket of personal injury cases that we'll talk about. They're almost exclusively cancer cases. There are property diminution claims, and also then really a sort of a standalone insurance docket that is going sort of parallel, where a number of the defendants who either manufactured firefighting foam, used it, are seeking insurance coverage, and that is playing out in that same MDL. And then the exposure pathways. I think are known, but just highlighting them for folks. Municipal water supplies, those are the water district claims. That really started the MDL and got it moving. The foam itself, through training, probably thousands of sites around the United States, maybe even more, airports, depots, anywhere that this foam, which is highly effective on significant fires, was used or trained with, which was almost all of these facilities had requirements in terms of yearly training, and all of those sites are at issue. And then for a number of the personal injury claims, through exposure, through PPE, so firefighting gear and related turnout gear, there's a docket that is involving that exposure pathway as well. Beth, you can go ahead to the next slide. This litigation, in addition to making a lot of law, has also resulted in a number of settlements that are sort of identified here. I think folks have probably seen the press coverage, significant amounts in terms of the settlements in the billions of dollars that are going to be funded over decades. And what's important is that these settlements are only for the water district claims in terms of retrofitting current wastewater treatment facilities to address PFAS in processing of drinking water. It is only for those claims, and it's both retrofitting and then for municipalities that hadn't done the testing to identify whether there was PFAS in their source water. There's a testing program that's now been set up through these settlements. There have been a significant number of opt-outs on behalf of single municipalities that go on their own, and those have resulted in a number of one-off large water district settlements, particularly around the South in the last year or two. And those continue to be litigated outside of the sort of the settlement process and continue to be filed. And then the personal injury cases that I touched upon, almost exclusively cancers. The Judge Gergel in the MDL has 6 that he has set up for discovery: kidney cancer, testicular cancer, ulcerative colitis, thyroid disease, liver cancer, and thyroid cancer. And you can see there that there are trials that have been set, and there was a science day just recently in June, I believe June 20th, where both sides had experts who spoke to the court, and that's becoming more of a process in the MDLs, where judges are holding science days to hear from the experts. I believe they are not transcribed, and so the judges can start to understand the science. And then we just had breaking news in the last day or two. Judge Gergel just issued an order pulling down the October 20th, 2025 trial date and all other case dates with respect to kidney cancer cases because of the disclosure of the existence of what he called a large number of unfiled cases. And so has put the parties on a separate schedule to get those cases on file. And I believe the projections are they're in the thousands. And so the judges put a hold on this process. It's been going on since 2018, at least with respect to trials, and wants to sort of get a handle on the true number of cases out there. So that's sort of an overview. We're going to switch now. Go ahead, Beth, to the next slide, and Michael's going to pick up with the expanding litigation we're seeing.
Yeah, you bet. Thanks so much, Shannon. I mean, that was a really helpful sort of background on the history of this litigation. Sort of starts with the manufacturers, spills over into the water districts. And now in the course of those and the settlements that have occurred, tens of $millions in fees have already been awarded to these plaintiffs' firms, right? So that's in connection with the 3M resolution and other aqueous firefighting foam or AFFF settlements. And so now that these plaintiffs firms have sort of gotten their hand in the cookie jar, there is a lot more energy around this in the plaintiffs bar, in the litigation finance community, and PFAS litigation is expanding at a really incredible rate and in surprising directions. It's no longer just limited to these water district cases or the firefighting foam cases. It is an expansion that's fueled by a really well-funded and a highly motivated plaintiffs bar that sees PFAS as the next asbestos, but maybe even more ubiquitous in our environment, leading to even bigger recoveries. And so the cases we're seeing, Shannon mentioned, cases over firefighting gear and other types of protective gear. We even saw a class action filed on behalf of American Airlines flight attendants who brought a class action in California for PFAS exposure from their uniforms, right? Flight attendants have uniforms that are designed for purpose, and that includes treatment for stain resistance and other types of chemicals that has led to allegations and a class action related to that. Cases are spinning into what we would think of as like consumer fraud suits about deceptive labeling. You know, you claim that this product is purely what it is intended to be, but in fact, it contains PFAS and that wasn't included or disclosed to the consumer, and then using really expansive consumer fraud statutes in creative ways. And that's like way beyond what we saw in sort of Gen 1 of this litigation, and the potential realm of targets of that litigation are now innumerable. At the same time, we've seen expansion of regulation at the state and federal level. We saw PFAS designated as officially as hazardous substances under the Surplus Superfund law. Now that's being rolled back to a degree by the Trump administration. We also saw early on some states like Maine being out front and developing reporting obligations for companies to disclose the use and the manufacture of PFAS. Maine was the first of its kind in the nation to do that. And they said, look, we're going to make all of these companies that operate here disclose that this stuff is used. Now, the companies were really worried. Shoot, if we disclose that we are using this, that we're manufacturing this, we're worried that it's going to trigger a bunch of lawsuits. Sure enough, that's what happened. They did these disclosures. The plaintiffs bar quickly filed FOIA requests, clearly prepared to litigate those to the hilt, obtain information about what companies were using this, which wasn't previously required to be disclosed anywhere. And then they filed lawsuits against those companies. And the statute in Maine and elsewhere, many of them have since been amended to try to address some of the reporting obligations and the timing around those to make it less fraught for manufacturers. But states are sort of stepping in to fill the void in the lack of federal regulation in this arena. And that can create a really risky patchwork situation that can create liability in surprising ways. Moving to the next slide, continuing, Shannon mentioned this trend towards downstream targets, right? Away from manufacturers and water districts and going into or further beyond the normal supply chain of what you'd imagine. So PFAS, it makes its way into water. And when it makes its way into wastewater treatment plants, it makes its way into the sludge in those treatment plants. And the sludge of those plants has a beneficial use. It's often used in agricultural operations. It's used as fertilizer. It's used in irrigation. The water from those treatment plants is used in irrigation, in landscaping, in livestock operations, and farmland. And testing is revealing that once that sludge is used in a farm application, that the PFAS that had aggregated in the sludge makes its way into crops, and it makes its way into the livestock that eats those crops. And so liability follows that all the way down, not just through a supply chain, but down the pathways that this permeates in our environment and in our food supply. Landscaping companies use this sludge and compost as fertilizer through the biosolids markets, as well as in irrigation water and landscaping applications. Shannon also mentioned industrial applicators of different types of coatings and lubricants. They wouldn't have imagined that they would be facing liability for the PFAS that comprise those coatings and lubricants, but that's also happening. Even companies that inadvertently introduce PFAS into their products are finding themselves pulled into litigation. So an example would be water sources for beverage manufacturing, right? We know that there's a tremendous amount of processed water that is used in manufacturing, but there's a whole lot of water that's used out of our local water supplies to create the beverages that we go buy when we go to the store. Those can get PFAS in them and trigger liability for those manufacturers of a good that they had no idea they were incorporating PFAS into. I mentioned industrial farming operations and how it can wind up in crops and livestock. And these examples really show that this risk is no longer confined to chemical companies. It's now expanded into commercial product companies, and it touches on basically every sector. We're also seeing a lot of trends as state and federal governments try to step in and do more in this arena. I'll give you a few examples here. The Biden administration and even the tail end of the Trump administration took some action to more aggressively regulate and get their arms around these compounds, where they were, and to do greater studies and create a framework for remediation of some of these sites. And when that initial pass towards greater regulation happened, there was a big blowback. So both Trump 1.0 and Biden pushed forward with regulatory action on PFAS, and industry stakeholders quickly locked arms and brought challenges because of the tremendous cost that this could impose on even passive recipients of this. Examples of those types of regulations involve a maximum contaminant level, or MCL, that in 2024, the Biden administration rolled out for 6 specific PFAS, as well as the designation of 2 PFAS, maybe the most notorious, PFOA and PFOS. These are long chain PFAS that tend to bioaccumulate in mammals. And so they were of particular concern to the administration. Those were officially designated as hazardous substances under CERCLA, which triggers reporting obligations. It imposes liability for cleanup by both past and present owners of different commercial sites. So these were really significant regulatory moves. Industry groups band together. They file a challenge in DC Circuit Court, which triggers a stay of those requirements. And in May 2025, the Trump administration rolled back the MCLs for all 6 of those PFAS, with the exception of the 2, PFOA and PFOS, which have been more closely studied. And EPA is reviewing that hazardous substance designation under CERCLA for PFOA and PFOS as well. So this is an area that's really in flux. And you've seen how a proactive and engaged litigation strategy can shape government policy in really significant ways. But that's not limited to industry groups. So state AGs and environmental groups have also decided to actively litigate to push the Trump EPA even farther than they were signaling they wanted to go. In January, 15 state AGs filed an amicus brief in support of the CERCLA designation for PFOA and PFOS. You also see local governments getting in on the action in creative ways, right? You saw local wastewater treatment plants that they have claims for this byproduct that's coming in and accumulating in their wastewater treatment plants that they have an inability to clean out of. But you also see now Savannah, Georgia, in February, filed a lawsuit claiming drinking water contamination in Savannah. But they didn't just go after manufacturers. They went after direct contributors as well as indirect contributors. So it wasn't just manufacturers. It was people who were involved in paper manufacturing, packaging manufacturing, fabric coating, textiles, roofing, insulation, even radiator manufacturers that may not have known the products they were using and they were ultimately discharging, were contributing to the pollution or contribution of PFAS into Savannah's drinking water supply. So that sort of shows the significant reach of government-driven regulation and litigation. You kind of have a movement at the top from the big federal regulators to define how these compounds are going to be treated. Industry groups, environmental groups, state AGs, all engaged in the fight. And meanwhile, local water districts are trying to figure out what to do, and they're getting more aggressive in going after broader indirect contributors. That spills over, Shannon, as we talked about, into issues around biosolids, which we'll get to a little down the road.
Yeah, and before we jump to Ryan's discussion that's here on this next you were on the right slide. I wanted to get your reaction, Michael, to we talked about it, the New Jersey Attorney General and the settlement they just announced with DuPont, $2.5 billion to be paid over 25 years for all environmental claims dating back over 125 years. Started as PFAS and now is sort of this all-encompassing kind of settlement. I wanted to get your reaction to that, whether you think that's the future or an anomaly.
Well, look, New Jersey is unique in the because of the industry that was there for as long as it was there. They have a very unique aggregation of these types of compounds in the environment there, and a really significant problem to confront. But there are other places in the United States because of particular types of manufacturing. I think of carpet manufacturers around Georgia, textile manufacturers here in North Carolina. There were industries that were pretty intensive in their use of these compounds for different fabric treatment purposes or otherwise. And so there are hot spots of this around the country. And North Carolina in particular is one of those states where the AG, as Ryan knows from his time there, has been pretty aggressive. And the sense I get in our conversations with state AGs around the country is that they felt like industry was really putting up a fight, and they were hunkering down and prepared to litigate to the hilt with industry. And this revelation of the settlement in New Jersey actually provides something of a roadmap for how these claims might get resolved. And so I think for folks on the AG side, they now have a rubric that they can try to follow. And if you kind of unpack that $2 billion resolution, you have a remediation fund for cleaning up contaminated sites. New Jersey is unique in its sort of number and quantity of those sites, but that's one component of this. You have a reserve fund to ensure that the cleanup obligations are met, like even if these companies face real financial difficulties, which is a significant risk for some, as well as you have $875 million in damages and penalties. And so looking at those buckets, I think a lot of AGs are thinking, okay, well, if this is sort of the formula and it's paid out over this lengthy 25-year time horizon, what may be a way that we can get some kind of global resolution to our claims as well? I think we could see this potentially become a rubric for what gets applied. It certainly has created an expectation in the eyes of state AGs that there's a playbook here.
Yeah, that's great. And I want to get Ryan's view, but let's go ahead to the next slide, and Ryan can sort of pick up this thread in terms of what we're seeing in terms of evolving trends. Go ahead, Ryan.
Yeah, happy to. So as Shannon and Michael outlined, we're seeing a wave of consumer-focused litigation where PFAS-related claims are being brought in connection with downstream products that allegedly have PFAS, and that end users, plaintiffs, individual plaintiffs who use those products have brought several lawsuits, many lawsuits relating to that. The difficulty that those plaintiffs have is there's a causation problem, right? So for any individual product that might or may not contain PFAS, it's hard to show that any trace amounts of PFAS that you might have been exposed to in a beverage or in a toothpaste or what have you actually caused you any tangible harm. And so the plaintiffs in these cases have come up with a creative solution that has kind of migrated over from what is basically an entire industry of food and beverage misbranding claims that are based on statements that are made on packaging or in advertising related to building up the product that is being sold. So some of the examples of claims that have kind of served as the foundation for lawsuits are things like a product is natural, it's fresh, it's clean, it's safe and comfortable. Some other specific things include full of what's good for you, free of chemicals, feel good about what's in the bottle, and good for you. So things like that, some general claims that are made in product packaging and advertising. And the plaintiffs are saying, well, these things are not true because your products contain allegedly small amounts of PFAS. And so that is a creative, interesting solution to the causation problem. And it's rooted in a price premium theory. So the price premium theory isn't that I was actually physically harmed by ingesting the PFAS in the product. It's that I wouldn't have bought the product if I'd known that there were small amounts of PFAS in the product, or I would have demanded a lower price, or if I would have switched over to a lower priced alternative if both of them have PFAS. And so that is the theory of damage. But it also opens up a defense that has been widely successful. And here I can switch to the next slide here, which is standing. Thank you. So many of these claims have faced the barrier of standing, Article 3 standing, which of course requires the individual plaintiff to show that he or she has suffered an injury in fact. And so some of the efforts that the plaintiffs in these cases have taken to show standing have been reference to kind of general independent studies showing that there may or may not be PFAS in general categories of products. And so what you often see in these complaints is reference to this Notre Dame study from 2021 that shows elevated amounts of fluorine in a wide range of consumer products. And the allegations on that study have pretty uniformly failed because they do not show an actual connection between the product that was purchased and the testing that was done in connection with that study. And so to solve that problem, naturally, a lot of the plaintiffs have commissioned their own studies that are third-party independent studies that they say show that the products at issue in their lawsuit did contain PFAS. But also, a lot of these studies have a problem. Many of these lawsuits involving some of the examples include Tom's Natural and Fresh mouthwash, CoverGirl mascara, and other beauty products. The plaintiffs commissioned a study, and they say, we have done a study showing that we have found allegedly small amounts of PFAS in some of these products, but there's a missing link that the courts are identifying, which is, again, the plaintiffs are not saying, I bought a particular product, and this product was tested, and I am alleging that based on my testing of the product that I actually purchased, it contained PFAS. And so the claims have, for the most part, failed on that basis. Now, there's two theories that, other than showing that an actual purchased product had PFAS, that the plaintiffs had tried to use, and these, again, have not met success. So one is the allegation that the tested products were purchased close in time to the products that the plaintiffs purchased, and courts have pretty much uniformly said that that's not enough. You need to show the actual product that you purchased. And the next theory is that based on independent studies, the claim that PFAS is just systemically involved, in consumer products generally. As I'm sure the audience is aware, there's studies showing that there's PFAS in the dust, and there's PFAS, trace amounts of PFAS generally in a lot of the environment that we exist in. And so based on that allegation of systemic presence of PFAS, the plaintiffs are saying, well, it's deceptive to say that your product is clean or natural if there's PFAS everywhere. And that claim has pretty much uniformly failed. And what's interesting is there is a diaper claim involving a company, and there's a couple other companies that have this in their labeling, saying that they're PFAS free, explicitly saying my product is PFAS free. And plaintiffs has said, because of these studies showing systemic PFAS exposure in our environment, that can't possibly be true. But they don't, at least in these lawsuits, haven't paired that with an actual study showing I purchased the diapers, I've tested them, and I am finding PFAS in that independent testing. And for that reason, that diaper lawsuit and some others have not succeeded. And so there is one exception that is worth flagging, I think, and that is a lawsuit involving a recall. So there's a lawsuit involving pure Irish butter. So the pure was the allegedly deceptive labeling claim. And the company in that case recalled their product. So New York had passed a law that bans PFAS in food packaging. And after that law, this company voluntarily recalled its products. And a plaintiff sued saying that because of the recall, I am alleging that there is PFAS that had migrated from the packaging into the butter. But interestingly, there was no testing evidence showing of any kind, showing that the butter had actually, that PFAS had migrated from the packaging to the butter, or even testing showing that the packaging actually had been tested and contained PFAS. The injury, in fact, was connected to the recall. And the court in that case, the Eastern District of New York, upheld standing and said that based on the recall, that is a distinguishing factor that kind of obviates the need for testing in that case. So I think you could question whether that ruling is reconcilable with the other decisions. These are all district court decisions, by the way, non federal appellate court decisions. But that is the distinction that has been brought in. So there's a risk of a voluntary recall related to PFAS claims.
Ryan,
I think the last point,
Ryan, you've been a Supreme Court advocate. You clerked for Justice Souter, Justice Ginsburg. Could you just maybe contextualize for the audience where the Supreme Court is on standing issues lately, and how they might think about these types of arguments in that context and how they may fare? I'm not asking you to prognosticate on this specific theory, but the trend we're seeing.
Yeah, no, that's a good point to dial it up in terms of the overall kind of doctrinal picture that we're facing on standing. And yeah, in recent years, the court has tightened up kind of the rules on standing. I think the rules haven't changed, but their applications have been rigorously enforced, requiring to show an actual concrete injury that is traceable to the claims and that the plaintiff individually has suffered. And the court has ruled in several cases that that level of concrete injury is not met simply by the showing that there has been a law that has been violated, even a federal statute that has been violated. You have to show something akin to pocketbook physical injury that the plaintiff, him or herself, suffered.
Thank you.
Yeah. And yeah, so the last thing I'd say on standing is that generally in these cases, the plaintiffs have been allowed to amend their complaints. And the court just said, please add plausible allegations showing that the products that you purchased did contain PFAS, and then we'll move forward. And generally those amendments have not come, which is an interesting, I guess, non-development. So if we could, well, I think this is on to
Shannon. So we talked some about biosolids and how these particular compounds aggregate in wastewater systems, aggregate in the sludge, make their way into biosolids. And this is sort of a familiar theory in that the impact on livestock has been sort of the genesis and the root of much of this PFAS litigation going back to the West Virginia case in the 1990s. So it's a familiar pathway. But when you start to think about the amount of biosolid from wastewater treatment plant that have been spread throughout American farmland and used for fertilizer across innumerable acres of land, the risk and potential liability and cleanup could be tremendous. We're seeing really difficult causation issues that come out of this. And we're also seeing some defendants and targets of these types of claims relying on local state right to farm laws, which theoretically should shield farms from liability from things like nuisance claims from odor of a livestock or a hog farming operation. But we're seeing those types of statutes also be used to defend folks in claims related to PFAS that has turned up in livestock and in farming operations.
Yeah, I was going to say, Michael, thank you for jumping in while I was on mute and didn't realize it. But we did have a question that's right on this, whether we see issues arising with regard to PFAS and wastewater sludge. And if you go to the next slide, I think it sort of says what's coming. Here, really how it started was, a group of farmers in Maine were joined by farmers in Texas, as well as the Public Employees for Environmental Responsibility back in June of 2024, bringing a lawsuit in the Biden administration against the EPA to act under the Clean Water Act with respect to the spread of sludge, arguing, like Michael was saying, that there is water and land contamination that is a result. And there wasn't much movement until just recently. And you sort of see that there with EPA announcing a draft sludge risk assessment in connection with 3 applications. You see that right there, including incineration, which is a very interesting area, because I don't know that folks think about PFAS and air contamination, but there are certainly folks out there thinking about it and bringing lawsuits in terms of getting EPA to act. And then, Michael, I wanted to talk to you about this a little bit, sort of the related risks that we identify here for the landfill operators, the wastewater and produced water handlers and users, just the number of uses, whether it's irrigation for crops or dust control, spraying on roads. It's not just PFAS. 1,4-dioxane is now sort of cropping up. So I wanted to make sure you talked about that a little bit.
Yeah, certainly. When the EPA did this CERCLA designation, it was really interesting. They also issued some guidance that basically talked about their exercise of discretion as to how they would apply it. And they were careful to try to signal to passive recipients like municipal landfills that they need not worry, that those folks were not the target and that EPA did not intend to take an aggressive posture in heavily regulating those who don't make, use, or want this stuff and passively receive it. And but that was cold comfort, because that doesn't stop plaintiffs' firms or environmental groups from bringing citizen suits and from bringing their own claims related to this. And I think we'll continue to see creative ways that, even in the absence of federal or state delegated affirmative regulation and enforcement related to what we would broadly call emerging contaminants, that being compounds that aren't necessarily regulated as a listed pollutant in the various EPA statutes, we'll see private groups use the citizen statutes to try to push regulators to take action and push private parties to enter into settlements and resolutions and cleanups. So this is a real concern, and we are really adept at battling and fighting back against these types of citizen suits. We've done it all over the country, and I think, unfortunately, it's going to be an area we continue to see, not just with PFAS, but with other emerging contaminants that aren't yet regulated, and where the body of research and science still leaves a lot of questions as to the actual human health effects, if any.
Great, thank you. I think next slide, I think, Ryan, you're picking back up with some more evolving trends. There we go.
Yeah, and I can try to be quick here. So what's interesting here is that we're starting to see increasing PFAS-related lawsuits against the government as the defendant. And the plaintiffs are bringing creative claims to get around various doctrines like sovereign immunity that the government defendants have to these kinds of claims. Now, when we think of PFAS in the government, we typically think of government as the regulator, and we think of government as the plaintiff. A lot of, especially states and local governments, are bringing these lawsuits on behalf of their people or in a proprietary capacity, saying that they themselves have suffered harms. But of course, now the shoe can be put on the other foot. And the kind of typical claim that you might see is when the government is itself or has itself used products containing PFAS. And so you see that with the firefighting foam involving government military defendants, for example. So there's the cases out of New Mexico at an Air Force base. And the typical route that these kinds of claims would take would be through the Federal Tort Claims Act. And you have to navigate a minefield to get to liability and judgment through the Federal Tort Claims Act. And so plaintiffs in one case, the Schaap case in the Court of Federal Claims, proposed a takings theory against the government defendants in that case. And long story short, the claim failed for failure to show that the government either intentionally contaminated the surrounding property or that they directly benefited from the contamination the acknowledged contamination that did take place. And so the theory of benefit to survive a takings claim from that case is there has to be something akin to a classic regulatory taking, where the government is regulating in a manner for its own benefit that harms private interests. It can't be simply inadvertent use of a product when the government didn't know at the time that it was harmful to the surrounding landowners. So I think, and I'll just quickly run through these. I think these are some actually the more interesting claims because you're beginning to start to see not claims against the government as an actual user, like in the firefighting foam cases, but claims against the government as a regulator. So claims that are premised on the idea that the government is at fault for alleged contamination because they should have been doing more to prevent it or to mitigate it. And so there's a really interesting case that was just recently filed in New York, brought by an individual landowner, individual residential landowner, saying, I have received these notices that there's PFAS in my water. You're sending me bottled water. And I see that there are some efforts underway to create a new water district to try to deliver clean water to my neighbors, but I'm not benefiting from this. I've not been added to this water district, and the government is at fault for not providing me with clean water. So there's public and private nuisance theories, and there's also a state constitutional claim. And a lot of states have these provisions in their constitutions that require the government to provide clean air and water and a healthful environment, or language similar to that. And so it'll be interesting to see whether these kinds of claims where the shoe's on the other foot can succeed. And I'll just quickly take through these next ones. There are claims that involve This is the Washington case, the Olympic View Water Sewer District case, that involved different government entities kind of pitted against each other. And so in that case, a local water district said that a local school district was violating the Federal Safe Water Act by through some of their activities in pumping water, and that exposed their own children to allegedly to PFAS containing water. And so you're starting to see lots of claims involving governments, not only the plaintiff, but as the defendant. And that will be an interesting kind of new chapter in this litigation to follow.
Thank you, Ryan. I think the next slide is the Q&A slide. It is. And there's a question that was posed about, and Michael, you touched on this, sort of if EPA is going to sort of pull back and sort of relax on PFAS regulations, do we see any impact on lawsuits, and how? And I'll just flag for the audience, by some counts in 2025 alone, there have been between 250 and 350 PFAS-related bills offered up in 36 different states. And so I think you will see an impact, although it may be slow because of the various states' legislative processes. But I think there's definitely going to be an effort, particularly I think among the blue states, to kind of fill the gap. But that being said, it's even Republican states like Texas are very involved in PFAS issues as well. So I do think that's one area where you're going to see potentially a change in litigation. And then, what Michael touched on before, the litigation in the DC Circuit isn't going anywhere, with folks sort of, jumping in, whether they're state AGs, fighting EPA, or, environmental groups like we touched on with sludge, trying to press EPA, and those litigations are ongoing and will continue. The other question we received was in connection with a lawsuit involving Purdue, where they don't have PFAS in their processes, but it ended up in their wastewater sludge. We are seeing those claims a lot. Many times, as I think Michael touched on, they're in connection with processed water. That these manufacturing facilities that have no intention of introducing PFAS into their processes or into their products are determining that it is coming from their source water. I think there's some statistics out there that 98% of all bodies of water in the United States have tested for PFAS. Now, PFAS is 17,000 different compounds, so some of which have no detrimental effect or haven't even been studied. And so, I think that that is going to be an evolving area of litigation as sludge becomes and wastewater becomes more of a focus. Our clients are going to face that. I don't know if Michael or Ryan, you've got sort of a last minute reaction to that, but that was sort of my reaction.
Yeah, and look, you mentioned earlier air deposition. I think that's going to continue to be a significant issue. Even when you have incineration of waste, you still have a risk of air deposition, and oftentimes that will show up it will deposit on land in surprising locations, sometimes far, far, far off from the source, based on whichever way the windrose blows. And then it turns up in well water around homes. And so you'll see local, state environmental regulators testing that well water, and the only explanation for it being there is air deposition from a very far distance away. And we've seen that as an issue as well. So you don't even know where it's coming from. It's not even in your process water, but it may deposit in a location that then somehow makes its way into a commercial operation.
Yeah, and that was related to another question we were asked in terms of with PFAS air emissions. The question was, what are they even based on if there's not air testing being done? I think you just answered the question, which is creative ways of figuring out how it got where it got, and attributing it to air deposition.
Right.
So I think there's one last question that is, in the absence of federal action to regulate, there's an argument that there's no federal preemption. What are the implications for national distribution of end user products? That's probably a whole CLE on its own in many ways, but I don't know, Michael, if you have a reaction to that. I think there are a number of implications for end users and sellers. The Amazons of the world are already facing lawsuits where they have tried preemption arguments, and I don't know that they've been successful. So I don't know if Michael or Ryan, you've got any closing thoughts on that?
I don't. I've not looked into the federal preemption question, but I think it's an important one, and no doubt is going to be litigated. I see a lot of room for amicus briefing support by industry groups that, to some degree, are tuned up and engaged in this. Ryan, I know as a Supreme Court advocate, you've seen some of this, but I think that issues like this are fairly novel. And it would be wise for industry groups, some may be on the call or you may be members. If there's not a PFAS assessment strategy by that group as to what we're going to do to protect ourselves through this distribution chain, it may be time to visit that. And for a limited investment, you can get something of a playbook as to how an industry can speak up for itself as these issues reach our appellate courts, to try to have a body of briefing that can form a really strong argument on appeal as these issues get sorted out. But I think that's an area where, whether you're facing this now, you're going to be facing it, and getting engaged and starting to form a legal strategy, even at the industry group level, makes a lot of sense.
Yeah, I think that's right, and I also think it's true with respect to the Trump EPA reopening a number of these issues for public comment. Gives these industry groups the opportunity to be heard, and I think a number of people would say probably heard by a more willing audience, and I don't know that's being taken advantage of either. So I think both are sort of important last points, and I think we've answered the questions. Oh, I did see a question about whether the prior CLEs were recorded. Yes, they were. They are on the website under the Contaminants Compass page, and you can go back and view any of those. The next one, the fifth in our series, is October 18th, I believe, with one of our senior trial partners, Mark Anderson, who's American College of Trial Lawyers. We'll be holding a panel about sort of evolving and new expert issues in PFAS litigation and regulatory. So we want to thank everybody again for listening in. Thank you to my partners, Michael and Ryan. I really appreciate it. I know you basically just got to the firm in the last couple months, so I do appreciate you jumping in here and being willing to participate. Really a great panel.
Thank you, Shannon. And everybody, reach out. We're thinking about this and working on it every day. So if you got a question, we're here for you, and we're happy to help form a strategy that's right for you.
Great. Thank you.
Thank you.